This internal contradiction in the attempt to achieve a genuine individualization of fines, which seems desirable in the light of major differences in standards of living, illustrates how much lower its subjective suitability is for a highly developed economic culture with pronounced differences of wealth than for more primitive and equitable conditions. Finally, it must be emphasized that fines are completely inadequate where only man's innermost relationships are concerned. From the 7th century onwards, penance could be absolved in money. The Church had taken over a large part of the administration of criminal law, which was really the state's domain, and the traveling bishop as a judge punished the sinner from the viewpoint of the violated divine order. Therefore, the moral improvement of the soul, the turning away from sinful pursuits, was the real intention of the punishment and was based on a deep-seated and effective tendency in religious morality. This resulted in the paradox that the positive moral obligation of man lay in gaining his own salvation, whereas secular morality transposes its final goal out of the self and onto the other person and his condition. As a result of this tendency to internalize and individualize punishment, even crimes such as murder and perjury were punished by penance through fasting. But, as noted above, these religious punishments could very soon be absolved by the payment of money. That such payment was later considered to be totally insufficient and inappropriate penance testifies not against but in favor of the growing importance of money. It is precisely because money represents the value of incommensurable things and has become more colorless and indifferent that it cannot be used as an equivalent in very special and uncommon conditions where the innermost and most basic aspects of the person are concerned. This is not in spite of the fact that one can obtain almost anything for money, rather, it is precisely for this reason that money was no longer used to settle the moral religious demands upon which religious penance rested. The increasing valuation of the human soul with its uniqueness and individuality meets with the opposite trend in the development of money and in so doing accelerates and secures the abolition of penance as a fine. Money first attains the quality of cool indifference and complete abstractness in relation to all specific values to the extent that it becomes the equivalent of increasingly diverse objects. As long as the objects that may be acquired by money are limited in number, and as long as an essential part of economic values is excluded from being purchasable, as was the case, for example, with landed property over very long periods, money itself retains a more specific character and is not yet indifferent to either side. Under primitive circumstances, money may even possess the exact opposite quality of its real nature, namely sacred dignity, the quality of an exceptional value. I refer to the strict norms mentioned earlier which reserved certain kinds of money exclusively for important or ceremonial transactions, and specifically to evidence from the Caroline Islands. The islanders, it appears, do not need any money to support themselves because they all are self-sufficient. And yet money plays a significant role, because the acquisition of a wife, membership of the local state and the political significance of the community are all dependent upon the ownership of money. From such circumstances we can understand why money is not as common there as in our society in which it satisfies the lower needs rather than the higher ones. Certainly, the merely quantitative fact that there is not yet enough money to slip continuously through one's fingers delays during periods of production for one's own requirements the emergence of its prevalence and its precision. Therefore, it seems more apt to serve as a satisfactory equivalent for extraordinary objects such as human life. The progressive differentiation of people and the equally progressive indifference of money combine to make expiation for murder and other serious crimes by money completely impossible. The increasing inadequacy of money. It is interesting to note that awareness of this intrinsic inadequacy of money is aroused at a very early stage. In the earliest periods of Jewish history, when money was already used in exchange for women and for atonement, contributions to the temple always had to be delivered in kind. Whoever, because of his remoteness from the shrine, brought his tithe in money had to exchange it again into commodities at the appropriate place. Similarly, in Delos, the ancient sacred shrine, the ox remained for a long time the standard unit of monetary value. Among the medieval journeymen's associations, the older, church-related brotherhoods imposed punishments for specific offenses in terms of wax, for holy candles. The secular associations, on the other hand. The same kind of phenomenon was found among the Californian Indians, where, even after shell money had been taken out of circulation, it remained the gift to the dead for the happy hunting grounds. The religious flavor of atonement or payment as a whole in its archaic form already at this stage of development takes current money to be inadequate for the sacredness of the events. It leads to the same debasement of money as the contrary movement mentioned earlier, and at a later stage it further severs the value of man from the value of money, thereby producing one of the most important factors in the development of the importance of money. I want to mention here just one more manifestation of this trend. The medieval prohibitions upon taking interest rest on the assumption that money is not a commodity. On the contrary, money was considered to be inflexible or unproductive, and therefore it was deemed a sin to demand a price for its use as one would for the use of a commodity. During the very same period, however, it was considered not in the least sinful to treat a person as a commodity. If one compares this standpoint with the practical and theoretical notions of modern times, then it becomes clear how the concepts of money and of man move continuously in exactly opposite directions. The oppositeness of the directions remains the same, however, whether the concepts, with reference to a specific problem, develop towards or away from each other. The dissociation of the value of the person from the value of money, which is expressed in the downgrading of fines to the most minor offenses, is itself counteracted by another tendency. The legal retribution for injustice and injury that one person inflicts upon another becomes more and more restricted to cases in which the interest of the victim is expressible in money terms. If we survey the sequences in the stages of culture, then it will be seen to be less frequent at a lower level than at a higher one, and here again less than at the next higher one. This is especially noticeable in urban life, where circumstances ascribe considerably greater importance to money than do rural circumstances in those instances in which the general level of both remains relatively low. In modern Arabia, for instance, the vendetta prevails amongst desert dwellers, whereas wergild is paid in the cities. In urban areas dominated by economic interests, the value of a human being is more likely to be interpreted in terms of a sum of money. This culminates in a situation in which damage measured in money terms is granted a specific claim to expiation by criminal law. The concept of fraud, which could be clearly defined only in a social order based on money, illustrates this point very clearly. German criminal law recognizes an act to be criminal fraud only if somebody misrepresents the facts with the intention of procuring an illegal advantage for himself or somebody else. There are only 2 or, at most, 3 other cases in which German law punishes the misrepresentation of facts and in which individual damage inflicted upon a person is the grounds for punishment: the seduction of a girl by the promise of marriage, marriage with fraudulent concealment of impediment to marriage, and the intentionally false denunciation. In all other instances, where fraudulent cases are threatened with punishment, the damage is done not to the individual but to the interests of the state: perjury, falsification of elections, false excuses by witnesses and jurors, giving wrong names and titles to proper officials, etc. Even in these instances, involving the interests of the state, the punishment in general, or its amount, is often dependent upon the fact that the culprit was motivated by an economic interest. Thus, the falsification of passports, work rosters, etc., are subject to punishment where they are falsified for reasons of improving one's position. Typical in this respect is the fact that the falsification of personal status, substitution of a child, etc., is punished by a prison sentence of up to 3 years, but if the action was done for reasons of economic profit, with imprisonment of up to 10 years. Even though the substitution of a child may undoubtedly occur for more immoral and criminal reasons than economic profit, so that the worst criminal receives less punishment because he has no money interest, it nonetheless generally remains true that numerous fraudulent misrepresentations may destroy people's happiness, honor and belongings without ever being punished unless the swindler attempts to gain a pecuniary advantage. In that financial interests are involved from the outset in the concept of fraud, this gives to penal practice the simplicity and clarity that is inherent in the reduction to money, but at the price of leaving the sense of justice very much unsatisfied.